This conference will now be recorded.
The attendance will grow still better as we proceed and additional people will join us. I do want to thank in particular as well Connor for chairing the committee, the committee meetings for this project. This is an important one, but probably not an easy one. I want to thank Todd for the extensive memo he prepared on this subject, or report, and in particular for slogging through the CFR and identifying all of these agency rules on rules, as we're calling them. And I also want to thank the participants in the roundtable that Todd mentioned in his the memorandum that he circulated. And finally, I'd just like to, I know we have a number of special invitees at this meeting who, though not members of the committee or ACUS in particular, do have important things to say on our subjects, important information and important perspectives. And we very much welcome and appreciate their participation. The special invitees include several very good lawyers at the Department of Transportation, from whom we'll hear shortly. And one of the reasons that we're hearing from the Department of Transportation is not because it's the only agency that has promulgated a rule on rule, but it's probably the most visible agency to have done so, at least recently. And I think it is the agency that's attended to this subject most recently. So we appreciate very much the participation of the DOT lawyers who are on the phone and whom Todd or Connor will introduce shortly. And with that, let me turn it over to Todd. I think you're going to go through the roll and get a sense as to who exactly is on the line.
Sure, thanks, Matt. So I'm just going to go very quickly through the roll. I'm first going to call the names of committee members and alternates of committee members. If I say your name, if you could please enable your video, I think that would facilitate the discussion. So once I say your name, please just say here, just so we can be sure that your mic is working. Connor Rasso. Great, and I think also a good reminder, if you're not speaking to keep your phone on mute. Paige Bullard, government member. Clay Cook, senior fellow. I did see Clay earlier. And Clay,
okay,
can you say
thank you.
For your working?
Oh, yes, Clay Cook,
Great.
right here.
Thanks. Christopher DeMuth, public member. Jonathan Doles, government member.
Here, thank you.
Michael Fitzpatrick, senior fellow. Nathan Kaczmarek, liaison representative. And I wasn't able to hear you, Nathan. Could you just say here? So I think your device is not carrying sound, so we'll have to figure out a workaround for that. I'll make a note of that. Alice Kottmeyer, government member.
I'm here.
Great. Erica Lightson, public member.
I'm here.
Michael Livermore, public member.
Yep.
Great. Danny Fischler, alternate for Christina McDonald, government member.
Here, thank you.
Matthew Minnelli, alternate for Alfred Pollard, government member.
Yes, I'm here. Thank you.
Jonathan Rose, senior fellow. Jay Schwartz, government member. Sid Shapiro, public member.
Hi, good afternoon.
Ganesh Shataraman, public member.
Hi, I'm here.
Peter Strauss, senior fellow.
Hi, I'm here.
Jonathan Weiner, public member.
Here.
Anjali Singh, alternate for Chinyu, government member.
Here.
Okay. Are there any committee members of this committee, the Committee on Regulation, who I haven't yet called?
Robert Stone.
Okay, great, thank you.
Hi, it's Dan Cohen too.
All right, Dan, I'm not sure you're on this committee. I'm gonna go through the names next of the people who are
Okay.
not on the committee but are here. So just any other committee members? Okay, I don't think so. So now I'm going to call the names of people who are not on the committee. If I say your name here, we ask that you please do not enable your webcam. This is so we can preserve bandwidth, unless we've spoken already. So Andrew Emery.
Here.
Jeff Lubbers. Jeff, are you here? I think Jeff is muted.
Yes, I am.
Great. Dan Cohen, I heard you earlier. Robert Stone, we heard earlier. Kate Surgeon. Kate, are you here? I think I saw you earlier. You could just say here. All right. Jillian Metzger. Steph Tatham. I think Steph will be joining us shortly. Brady Tonsing. Kenny Wright.
I'm here, thanks.
Levon Schlichter.
Here.
Rylan Lee.
Here.
Jim Tozy.
Present.
Paul Noe.
Here.
Rob Carter. Jill Leptoski. Jill, are you here? Timothy Mullins.
Hi, I'm here.
Carol Miaskoff. Maureen Ruskin.
Here.
Lisa Stewart. Peter Robbins.
Here.
James Goodwin. Neil Eisner. Bridget Dooling. Christina Ice-Corby.
Present.
Radha Vishnu Vajala. Keith Holman.
Yeah, I'm here.
All right, those are all the folks who have RSVP'd. Is there anybody whose name I did not call yet?
Yes, this is Sheila Novak, alternate for Carrie Ritchie.
And what's your first name? I'm sorry.
Sheila.
Novak? Oh, Sheila Novak. Okay, great. Thanks.
This is Charlie Maresca, SBA Advocacy.
Great. Anyone else? All right, I guess that's it. So Connor, I will turn it over to you now for the announcement of the rules.
Oh, thank you. And thank you, everybody, for being here. I think there might be a little bit of a lag in unmuting, so we'll all just sort of have to, at least on my end there is, so we'll just have to bear with that. I'll just quickly go over the ground rules, which may feel a little bit different since we're all remote. First, all ACUS members have full speaking privileges and have the ability to unmute yourselves. That said, we'll have a lot of background noise if folks don't keep their microphones on mute when they're not speaking, so please do that. And if you'd like to speak and want us to recognize you to speak, I think since we have so many people here, it's best to use the chat function. With so many boxes, it'll be hard to see all the hands. So I would suggest using the chat function if you want to speak, and of course, remute yourself when you're done speaking. For members of the public, non-ACUS members, please also use the chat function if you'd like to speak. And then we will, at an appropriate point in the meeting, use the GoToMeeting software to unmute you. Please only use the chat function to request to speak, or if you need to, if we do take a vote, I don't know that we'll be voting today, but if you do take a vote, we'll use the chat function to vote rather than doing hands in the little boxes. But please, no substantive discussions, no substantive sidebars, so we can all focus on the meeting. Otherwise, things are going to get a little bit too unwieldy to have two simultaneous discussions going. And as you know, only members of the Committee on Regulation, so that includes government members or their designated alternatives, and we have a few of those here, public members, senior fellows, liaison representatives, and special counsels have a vote if we do vote. So please don't vote in the chat box unless you're in one of those categories. And if you have a question, just write us in the chat function, and we can respond through the chat function. And as I said, if we do vote today, we will use the chat feature so we can tally it up quickly. So those are the ground rules. And with that, I'm going to turn the floor back over to Todd, who can give an overview of his research on this project.
Thank you, Connor. So just the memo, I think, lays out our thinking on this. So I don't have much more to add than what's in there. But let me first just say that this memo is very much a team effort. It was my colleague Keith Holman assisted with much of the underlying factual research, the product of which is the appendix on rules on rulemakings. I think it's Appendix A, or rather B, which lists the excerpts of the rules on rulemakings from different agencies. And so being able to kind of break down how the agencies issued those rules, some of them went through notice and comment, some invoked an exception. So Keith's help was very, very instrumental for that. And I also want to thank Mark Thompson, Reeve Bull, and Matt Weiner for helping to distill the very complex case law regarding whether something is a legislative rule or not. They really took this, I think, very complicated body of case law and synthesized it in a way that didn't lose its complexity. So I thank them very much for that. And also, perhaps most of all, I want to thank the experts at ACUS, the government members, liaison representatives, senior fellows, so on, who took part in our roundtable in March, and many of whom agreed to speak as a follow-up to that roundtable. And the section on policy and legal considerations largely derives from those conversations. So thank you to everyone. And just to reiterate, this is very much a team effort. So the memo lays out the methodology that we use to determine how many agencies have issued pronouncements that we think are rules on rulemakings. And I'll just illustrate some of that methodology for you now. I'm going to share my screen. Okay. So what I did was basically just went through each title of the ECFR and took a few hours to do this over several days, but it's a very replicable methodology. So I'll just show you one agency. We click on, this is Title 14, Aeronautics and Space. You see those agencies, NASA and FAA, a couple others that are located here. And so for each title of the CFR, I browse the parts of each agency. And so if we just click on the first part here, as you can see, the headings are clearly labeled. So I didn't have to read through every single chapter and subchapter of every agency to find a rule on rulemaking. I was able to very quickly home in on the part that was likely to have their rulemaking procedures. In many cases, the headings were very suggestive of the fact that there would be a rule on rulemaking involved. So general rulemaking procedures, sometimes they said administrative requirements, sometimes general requirements, but at any rate, it was pretty easy to identify the part that would likely have a rule on rulemaking. So if we click on general rulemaking procedures here, we pull up the FAA's rule on rulemaking, and they're formatted differently. They seem to do it in this particular agency does it in kind of a Q&A format, but other agencies do it differently. At any rate, I did this for every agency. As the memo pointed out, there are 25 of these things in the CFR. we call them rules on rulemakings, but we also note that as we define a rule on rulemaking as a legislative rule, we can't say for certain that each and every one of these would be found, if the issue ever came up in a court, that a court would determine it to be a legislative rule. We said that on its face, when something is in the CFR, it appears to be a legislative rule or a rule that has binding effects. But of course, commentators and courts could come to different conclusions. So I just want to point out that caveat. In addition to looking through the CFR, we also took a look at several websites, and I'll illustrate one in particular. So what we were looking for was not just the putative legislative rules that set forth an agency's rulemaking procedures, but also other documents that accompany those rules. And so those were found on agency websites, and the appendix points out the Department of Transportation has a page devoted to its rulemaking process, which has its rule on rulemaking, and also has these other materials that are related to the rulemaking process that we, in the memo, call explainers. And here's an example of an explainer. It's a section on the website that describes the department's rulemaking process. And they have a statement saying that it should not be relied on as a legal document. Other language in other places, this document does not have the force and effect of law. They clearly distinguish between what's a legislative rule and what are background materials that are intended to explain the process. And other agencies do that as well. So as I mentioned earlier, an additional part of our research was holding a roundtable with experts from ACUS and from outside ACUS. And many people in this meeting were part of that roundtable and part of the follow-up discussions. And so the expertise was extremely helpful. And the sections in the memo on, as I mentioned earlier, policy considerations and legal considerations largely came from these discussions. So the memo concludes with several areas of discussion for the committee. And I look forward to that discussion. And I also encourage anyone to ask any questions you may have about my research or about some of the findings.
Well, thank you, Todd. That's helpful, and thank you for your hard work, and to Keith and the others at ACUS for all the hard work as always. I just want to give a very brief roadmap of our discussions today. Today's a little bit different than some committee meetings in that we have sort of a list of discussion topics, but we don't have draft recommendations to start with. And so the goal is to get a sense of the views of the committee members, and use that to do some drafting. But the discussion will be a little bit more conceptual maybe than some committee meetings. So we'll try to get a sense of where folks are. As usual, I'm sure Todd would welcome questions or feedback on his memo, but we're not sort of as a committee revising the memo. It's more of a background product for a potential recommendation that we'll be working on. As Matt noted, Department of Transportation is probably the most recent agency to do rules on rulemaking, and so we're not encouraging the committee to adopt DOT's rules as a model, but rather to hear about their experiences in doing these rules. So with that, I will turn it over. Todd can introduce our DOT reps, and we can hear about their experience with rules on rulemaking.
Thanks, Connor. So we have from DOT today, Christina Ice-Corby, Jonathan Doles, Jill Leptoski, and Tim Mullins. So if any or all of you have just some observations about the process and about the rule on rule, we'd love to hear it.
Thanks, Todd. Can you hear me okay? Give me a thumbs up. My first time using this platform. Great, thank you. My name is Christina Ascorby. I am the non-career political deputy general counsel at the Department of Transportation. Obviously, very much appreciate the invitation and brief time to share some of our reflections with the development and codification of these procedural reforms into the department's code. This is really exciting work and a very exciting time to be at the Department of Transportation, which is a regulatory department for these types of changes. And I know that I see many of my former colleagues and individuals here whom I've crossed paths with who are very invested and committed to regulatory reform and these concepts of administrative law. And in my short experience at the department, I've been there since May of 2018, so just over 2.5 years. It's been fascinating to see them adopted and utilized across all of our modes. So I will say, you know, this process began, I'd say not even in this administration for DOT. Jeff Rosen, who I'm sure many of you know and are familiar with, has personally been invested in a lot of these concepts that we've now adopted into our regs through our rule on rules back into previous administrations. But this administration, we began our work at the department through 3 separate documents, an order on our rulemaking processes and 2 general counsel memorandums, one on our guidance review and procedures, review and clearance procedures, I should say, as well as a general counsel's memorandum on our enforcement processes. And all 3 of those documents were published, the first 2 in December of 2018, and then the enforcement memo shortly thereafter in February of 2019. So by the time we began rolling these procedural reforms into our rule on rules, many of these practices had already been in place at the department before even our order and general counsel memorandum were issued. So for the department, it was a smooth transition, relatively speaking, to the point at which we were implementing these reforms and referencing them in our own Code of Federal Regulations. So that made the transition to their adoption quite fluid at the department. And they do address, at least with respect to our rulemaking reforms, many of the concepts the president included in his 2 regulatory reform executive orders at the beginning of the administration, including the 2-for-1 rule, the regulatory reform task force, regulatory budgeting. But of course, these were all included in the appendix, so I don't need to go through them all. But they have contributed to a great amount of success, I would say, and consistency in our rulemaking practices at the department. So far, we're at a 75 to 6 approximately for our 2-for-1. And because in large part due to the Safe Vehicles rule, which updated the corporate fuel economy rules, we've saved over 93 billion this term. So we're very proud of these achievements. Like I said, they've been extraordinarily efficient and promote consistency in the department's activities. And Todd, I will say from your memo, noteworthy, I think you captured the core benefits that we've identified from these procedural reforms. First being predictability. You know, when there's any question over how to treat the development, review, clearance, or publication of our rules, there is essentially a one-stop shop for us to reference or point the public to. So it does enhance predictability and transparency in that regard. And it has very much streamlined our internal processes and enhanced the logistics of rulemaking. You know, there's a lot of concern, and I think the memo pointed out in one respect, the fear that a rule on rules and these additional procedural concepts might slow down regulation. But for us, the additional review within our Office of Secretary and requiring not only significant rules, but all rulemakings of the department to come up for secretarial review and approval has actually helped streamline that process. The RRTF ensures that there's buy-in for the policy decisions that are made in our rulemakings early on, because the RRTF, through the Regulatory Reform Officer, must approve of any new rulemaking identifiers that are pulled with OIRA. And those concepts and the agencies don't have to expend a lot of resources and time working on something that ultimately doesn't have the political and leadership approval on the back end. So I think that, you know, those two concerns, I think that the memo identified, the slowing down of the process and reducing flexibility, are largely mitigated by the extra planning and the higher quality of our rulemakings because we have all of these procedures clearly laid out and the expectations are set on the front end. So I love this work. This is what I've contributed my career to, and so I'm thrilled to hear that ACUS has taken this up and is starting to look at how this can be done across the government. I know that the recent executive order on guidance required departments to focus on implementing their own rule on guidance practices, but this administration has also prioritized internally departmental work on adopting rulemaking procedures to codify these concepts as well. So we are very proud of this work and think it works very well. And it does reflect a lot of concepts from recent and repeated legislative efforts like the Reg Accountability Act that I think now we have a demonstrable example of these concepts working in practice. So I've talked enough. I will defer Jonathan Doles, my senior most career colleague in our Office of Regulation here, who's with us, if I've missed anything. But like I said, very much appreciate the invitation. And I am sorry that Steve Bradbury couldn't make it, our general counsel, and performing the duties and functions of our deputy secretary. He was also thrilled to hear when you started up this project. So thank you for this.
Okay. Thank you, Christina. I really appreciate that. I'll go over a few things that you didn't cover, but first let me introduce myself. I'm Jonathan Doles. I'm the Deputy Assistant General Counsel for Regulation here at DOT. This is my first committee meeting as a voting member. I've replaced Jonathan Moss, who sadly to us all left for a private sector job in the summertime, but he reports that he's doing well and loves his job. I also want to just say hello again to Todd and Reeve and Mark in particular, with whom I've worked recently on several projects, and then generally express my thanks to ACUS for our participation in this, and we certainly extremely value the relationship that we have. Briefly, just I won't completely go over what Christina has done. The origins of the rule, the provenance is sort of many. You know, success has many fathers, I suppose, fathers and mothers. And of course, starting with the administration and its focus on regulatory reform, clearly that's what enabled this, and we've codified much of that in the rule. But the concepts and philosophy in much of it go beyond and have been held by senior DOT leaders for quite some time, and by others in the administrative law community for decades. So some of those ideas had been floating, and this was the opportunity to crystallize them and put them into action. And then, of course, there just are the general values that we all share about good government, transparency, fairness, and those things were motivating us all, and always have been motivating us. But this was a great opportunity to get them in there, and you'll see those enunciated in our principles section in particular. The reaction we've had to the rule has been positive. We believe that it's internally, it's brought rationality and coordination to the rulemaking process. It's allowed us to speak consistently as a department and improve the quality of our rulemakings, and with our rulemaking quality officer, amongst others, and other procedures we put in place. and then, as Christina mentioned, streamline the process. So we think that you know, in toto, this has been a very, very important part of our success to date in regulatory reform, and we believe that it will carry on an important legacy into the future on you know, the proper rulemaking, etc. So now I'll turn it back over to Todd.
Great, thank you. And I in turn will turn it over to Connor.
Thank you. So I'm now going to turn to committee discussion. Just as a brief roadmap, we will do, let's say, about 15 to 20 minutes of general discussion, and then we will dive into some of the specific questions posed in the ending portion of the memo that Todd sent around. And we will also take a break around 3:15 or so, because online meetings can be hard to go so long. We have the time booked until 5, but hopefully we can end a little bit before that, just because I know it can be difficult to do an online meeting for so long. So with that, please use the chat function if you'd like to be recognized for general discussion.
We have Peter Strauss.
There we go. This is a terrific project. I especially like the explainer function, and hope that ACUS will recommend that broadly. People can go to Congress and read its perhaps over technical description of how law is made. But the notion of having an explainer on every agency's website that tells people how rulemaking occurs is useful. What I have for discussion is maybe rather technical. One thing I didn't notice in your report, Todd, but perhaps it was just my not noticing it, that there's any attention at all to the way in which the executive orders play in on rulemaking. And as we just heard, that is indeed important. So if ACUS is going to make recommendations about what ought to be in the rules on rulemaking, it seems to me that those recommendations ought to include attention to the involvement of the White House, the way in which that occurs, and to how it affects rulemaking. And I suppose that would include the internal measures over setting priorities that have been discussed. I think that the memo uses the idea of bindingness in discussing the difference between guidance and legislative rules in a way that, in my judgment, is just misleading. Binding really has two different characteristics. And sometimes the memo suggests that when it talks about things that are binding on the public, but in general, it does not open the possibility that a guidance document can be binding on, that is to say, within the agency. Not necessarily enforceable from outside, but nonetheless regarded by people inside the agency as what it is their obligation to do, and they're subject to discipline if they don't do it that way. And I think that's something that ought to be there. And finally, this is really technical. At one point, you talk about the publication of guidance in the Federal Register. And it has always seemed important to me that 552A1 talks about a guidance that has been adopted by the agency, and 552A2 does not. So when I was general counsel of the Nuclear Regulatory Commission, boy, did we have a lot of guidance. It filled bookshelves. but I never heard the commission adopt any of it, and nor did we ever send any of it for publication in the Federal Register. And both of those seem to me quite correct. It would expand the Federal Register beyond belief if all guidance were to be published there, anything that fit the 551 definition of a rule, that is. But if one distinguishes between guidance that is adopted by the agency and guidance that comes from staff, you've avoided that problem. Thank you.
Peter, on your first point, are you primarily referring with respect to the EOs to the regulatory plan, or what else did you have in mind besides the regulatory plan?
By the first point, you mean talking about executive orders?
Yes.
There are a lot of them. 12866. There's the regulatory plan is only part of that. There's the necessity to clear things within the agency. All of that ought to be in the rules on rules.
Todd, did you want to respond on the second point with respect to bindingness?
It's a difficult question. I mean, certainly it's true that guidance, if something is termed a guidance document or it's not a legislative rule, Peter, as you pointed out, it can't be, there's no enforceability. The court can't enforce it as though it was law. I mean, I think it's also true, though, that if something is a guidance document, the practical effects of it within the agency are such that employees can regard a piece of guidance as being binding in the sense that if they don't follow it, they can face repercussions.
They can be disciplined, and if they're disciplined and it goes to the Merit Systems Protection Board, one would expect the board to uphold the discipline. And if that goes into court, one would expect the court to say, yes, that's proper.
We have Jeff Lubbers next in the queue, but any other follow-ups directly on Peter's 3 points before we move on?
Connor, if I may, I think Peter makes on the question of bindingness, I think he makes a very good point about whatever you want to call them, policy statements or so forth, that may well be binding on agency officials, even if they don't create any enforceable rights in the public. And I think that's probably something that Todd, it's obviously something for the committee's discussion, but probably something that Todd should take up in the next revision of the memo.
Thank you, Matt.
Could I also add something on this point? And I'm new, so hello to everybody. This is my first meeting. I am aware of at least one agency that has a regulation saying that its guidance is binding on its agency staff. And that's FDA. So they have a regulation and it says it's binding if you can, there are certain conditions in which you can deviate, and it spells them out, but at least purports to make them somewhat internally binding.
If you have time to send that to Todd, that would be terrific.
I'll do that.
Any other direct follow-up to this line of questioning, and then we'll move to Jeff.
Hi, it's Jillian. Can I say something?
Please.
Sorry, I'm both a caller and I'm there. I can't get my audio to work.
I see that big phone there.
Exactly. I just wanted to flag, I think Peter is absolutely right, but I think some courts have taken different views on this. And so just for Todd in writing it up, there are some courts that are more recognizing of exactly Peter's point, and then there's some that are much more restrictive in terms of if it's binding, putting it into the legislative camp. So just to flag for your write-up that that's something you may need to be sensitive to.
Thank you.
Okay, hearing no further comments, I'll turn the floor over to Jeff Lubbers.
Thank you, Connor. I think it's a great project. I'm sorry I'm coming in a little bit late on it. But I have a slightly similar concern to what Peter raised. I think our overall goal here is we want to have as much information about agency rulemaking practices available, whether on the agency's website or maybe in the CFR, not necessarily in the CFR. But I think that the focus on the difference between a legislative rule that sets forth rulemaking practices and a non-legislative rule that does the same thing could cause a few problems, because when I read the report, the rule on rulemaking is defined as a legislative rule. And I think it might be better just to talk about rules on rulemaking, whether or not they're legislative rules or guidance documents, because later in the report, it mentions that legislative rules are binding on agencies and the public. This is on page 5. Agencies therefore must adhere to their legislative rules. And I fear that that might disincentivize agencies from putting out their rulemaking rules for public comment. They'll fear if we go through notice and comment on this, that's going to turn it into a legislative rule, and then it's going to be binding on us. And if we deviate from it in some way, we could be called to account on that. And I think some of the appendix rules do use words like will and must and things like that. And I think Peter's right that we're not likely to have people going to court to say, the agency said it was going to review all of its rules every 5 years, and they haven't done that. But I think we don't want to discourage agencies from getting public comment on their rules on rulemaking. So I don't really see the point of drawing this clear distinction between legislative rules on rulemaking and non-legislative rules on rulemaking.
Responses to Jeff's point.
I have one response. Where's the incompatibility there? Why couldn't an agency, why is there a disincentive to seek public comment, Jeff? I guess I'm not sure I'm following that.
Well, so I think some people think of legislative rules as rules that have gone through the notice and comment process, and that turns it into a legislative rule. Whereas if it's just a guidance document, it's exempt from notice and comment, so you don't have to go through it. And so, I know there are other ways to describe the difference between legislative rules and non-legislative rules, but if agencies feel like they're going to be bound by their rulemaking rules, if it's considered a legislative rule, then they might say, well, we better just issue this as, we better just put this on our website or issue it as a memo, and then people can see it, but we're not going to put it in the CFR. I think some of the cases make a big point of if something's in the CFR, that's one of the tests for whether or not it's a legislative rule. I think the DC Circuit's, that's the American Mining Congress case. I think the DC Circuit has departed from that one criterion in a number of cases, so it's not really the most important of the 4 criteria in that case. But nevertheless, it's still one that a lot of people point to. So I guess I just don't see the point of trying to draw this distinction. Why don't we just talk about rules on rulemaking, and some of them should be put in the CFR and some of them can just be put on the agency's website.
I was just reacting to your question about notice and comment. The response you just made just sort of goes to the heart of the project, which is whether and when agencies should issue rules that might be called legislative.
or rules that might be put in the CFR.
Just to jump in here, I mean, part of this is also the problem on the line between procedural versus substantive rules, right? I think that there are many rules that you would want an agency to have the flexibility to be able to change without necessarily having to go through a full notice and comment, but you'd also want to get the option of having comment on or something, and it's balancing those two. And I think the category of procedural rule is sort of how this should be navigated in this space, and it is just problematic that the line between substantive and procedural is sometimes so shady. And also, some courts have really read procedural narrowly and not been willing to been concerned about it as a way of agencies might be evading notice and comment. So the net effect is that in order to get at evasion, they also end up limiting the ability of agencies to use this in a good way to sort of provide more notice and opportunities, for comment, for discussion about how they're proceeding without having that sense of binding. And I share Jeff's concern about the incentives that are created here if these are judicially enforceable in terms of a notice and comment requirement.
I'd also point out that ACUS has a recommendation on procedural rules, 92.1, which tries to sort of narrow that exception a little bit and encourage agencies to get public comments on procedural rules.
Just for what it's worth, the Department of State, if I may, the Department of State has a rule pending at OIRA right now, and it's been under review since January, February, and some radio silence since then. But it's a rule on rules, and it's a final rule, and it claims agency organization, procedure, and practice. So we'll see what they say about that. But like I said, there's been no feedback yet from OIRA, but it does change the CFR. It adds a new Part 7 to 22 CFR.
We have a little bit of discussion, substantive discussion in the comments. So let's shift that per kind of our ground rules. Let's shift that onto the platform here. So Paul, you were first. Did you want to say something, Paul?
Yeah, I mean, I guess my simple point is if you want to change the status quo, you should do a legislative rule. You should want the agency to be bound by it. And if you want to basically keep the status quo the same, then just do it as guidance, because that's what will happen. Nothing much will change if the agencies just do these as guidance.
Responses to Paul, and then if not, we'll shift to Peter Strauss.
So this is repeating what I said before. I think the most important point, the most valuable encouragement that ACUS would be giving to this recommendation is to have relatively extensive explainers. And that is to say things that educate the public as to how the rulemaking goes on in the agency and what their relationships to it might be and the like, without regard to whether they are legislative or legislative rules or guidance documents. I'd pay a good deal less attention to that distinction. You might get into it further on, but from my perspective, the principal good that this recommendation is going to do is to create a series of documents that are like the documents that Congress has up on congress.gov, saying to the public how legislation occurs, or for that matter, that are on regulations.gov, explaining in a general way how rulemaking occurs.
I think this discussion kind of is a nice segue into, again, Dan, I see your comment. Let's take the substantive discussion off the chat function and just use that for voting and for being called out. But this is a nice segue into question 1 that Todd has laid out about what are the key considerations in deciding whether or not to issue rules on rulemaking. I won't read all the potential benefits or costs. Todd summarized some of that in the beginning. So let's kind of use this as a segue into question 1 about considerations in deciding whether or not to do rules on rulemaking. Dan, if you want the floor, it's yours.
Yeah, I mean, it's sort of a follow-up and agreeing both with Peter and Paul, actually. I mean,
we just went through this revision to what we call our process rule. And this question about whether it was binding on us or not was part of the notice and comment process. We did go through notice and comment, but we didn't try to draw the distinction of whether it was a procedural rule, a legislative rule. We just took it as a more pragmatic thing, which was, if we're going to have a process rule, right? If we're going to write this down, we should follow it. Like, why would we go through the exercise of creating a process rule to then not follow that process? And we were giving our interpretation of the statute in key places, and we were explaining how we go about doing our various analyses and the kinds of data that we're going to look to gather to do those analyses. Why we're going to do those things, and if we're not going to do those things, we shouldn't bother going through the process. So we said it was binding on us because we're going to follow it. Now, obviously, we also said, if a court were to direct us to do something different, or if a statute told us to do something different, we're obviously going to follow what the court directs us to do or a statute tells us to do, right? Then that's a different scenario, right? But generally, we just thought the question about legislative procedure, whatever, just wasn't worth the time to get into if we were going to go through the exercise anyway.
Thank you, Dan. That's helpful. Sid has posed a quick question about the scope of the project, asking, are we limited to best practices that exist now, or can we go beyond what now exists as they should exist? And the ACUS folks should speak up, but my sense is we're not limited to current practices. Todd surveys current practices, but to the extent we think there's a basis to go beyond that, that's a possibility.
Thanks for noticing that, and I don't mean to butt in, but I have to leave at 3 to teach. So I appreciate you taking my question, and I'll wait for the response.
Reeve, why don't you jump in if you think I'm mischaracterizing anything? That question is a little too general, I think, for me to answer. But I think insofar as I understand what Sid is getting at, the answer is that ACUS is not so constrained. Is that right, Reeve?
Yes, I would agree with that, as I understand it as well. And certainly we can, offer recommendations on what best practices should be. The existing practice is useful background, but the committee should feel free to go beyond that.
I could be more specific, and I'm taking this as an example and not necessarily endorsing it at this point. But there's been some interesting discussion lately, at least among law professors, about the practical or structural inability of marginalized communities to participate in rulemaking, and that maybe the agency ought to have affirmative responsibilities to reach out to at least representatives of those committees and obtain their input. That's a complicated subject, but it seems to me one on the horizon that either in this project or in a separate one, ACUS probably ought to address.
Sid, you know what might be useful to without sort of speaking to the sort of merits of your suggestion, is for you and other committee members to take a look at a recommendation that ACUS, I think, issued in like 1968 or 1969 on the representation of the poor in the rulemaking process. And maybe we could have further discussion after the committee members have looked at that recommendation, but I leave that to Connor to decide in the first instance.
I think it was 68-1.
68, okay, 68-1, there you go.
Well, I can say that was before my time, but that that was before my time. I think that's a very positive suggestion.
Follow-ups on Sid's point. Thank you, Sid. Erica is next in queue.
Yeah, I wanted to express a little concern about endorsing explainers. I see a great deal of value in sort of plain English explanation to the public, but I'm concerned about something that is not binding that might be yet a third sort of source of information. I worry that that will sort of be contrary to the goals of transparency and accountability, because it will be worded differently. And I guess I'm concerned about sort of the proliferation of different ways of communicating this information a little bit. So I'm not sure that I view that as the best thing that might come out of this conversation. That's all.
Welcome follow-ups on Erica's point. Reland, is that how you say it? Reland? You could speak.
Hi, it's Ryland actually, but
Sorry, my apologies.
no worries. Thanks for the opportunity to speak. It's my first time at an ACUS meeting and really appreciate the fantastic discussion here. So I just wanted to kind of dive into the benefits of having a legislative rule on rules versus having some type of process manual that's also available to the public. And I haven't given a great deal of thought to this myself. I appreciate other folks' views. So, looking at the list of benefits, the 4 benefits on page 9, I think all 4 of those would apply, whether there is a legislative rule that's in the CFR or whether there is just a process manual that's available to the public. I think the 2 vehicles may differ in a few ways. The first and maybe most obvious way seems to be that a legislative rule can be judicially enforceable against the agency in the way that a process manual is not, whether because that rule imposes binding legal requirements, or even if it's not binding, right? Like the DOT rule in Appendix B, there's a disclaimer that says this is not to be judicially enforceable. Even in that case, I think it's quite possible that a court may view something that's in the CFR as creating some kind of standard that it's going to subject the agency to more rigorous, arbitrary, and capricious review for than if the agency just published the exact same language in a process manual that's available to the public. I think a second difference, and here I'm just speculating, could be that depending on the vehicle in which the rule on rulemaking is produced, that the kind of agency's internal review may differ. So for instance, I wonder if in one case, perhaps the Office of General Counsel will have a stronger say in enforcing these procedures as opposed to, say, a policy office inside the agency. Again, I haven't done any work on this, but just to throw the idea out there for folks to think about. And the last reason is what Erica mentioned a moment ago, that perhaps by drafting something that is called a rulemaking and that is put into the CFR, that incentivizes agencies to write that document differently, and in the process of creating those rules to come up with language that's just more definitive or more clear than if the agency was creating its own process manual. Again, haven't done research on that topic, but just some thoughts to throw out there. With all that said, though, I do think a lot of these benefits on page 9 apply to regardless of which vehicle the agency uses.
Ryland, can I just ask you to clarify one thing, that the first point that you raised about judicial scrutiny? So your argument was that courts would be more likely to scrutinize legislative rules than they would process manuals or similar vehicles?
Sure. So what I meant was, in both cases, the agency is creating procedures to govern future actions, right? And when the agency takes an action in the future, can somebody litigate that action for the agency's failure to follow the procedure it has set out? Now, if the procedure is set out in a legally binding rule that's in the CFR, then I think the answer is yeah, probably, right? But even if the procedure is not binding, a court could potentially review the agency's failure to follow it under arbitrary and capricious review. And one might speculate that some courts would apply that review more stringently if a non-binding procedure was included in a rulemaking document as opposed to in a, some type of PDF on the website, for instance.
Further reactions? Additional points on costs and benefits. Do folks have additions to Todd's list of different benefits and costs, or views about how the benefits and costs are framed in the memo?
I would just quickly add to my last point, since you also asked about costs, is I think a significant cost of having a binding rule is judicial review. That that's a benefit in terms of public accountability and transparency, but I also think that is a cost to the agency in terms of more scrutiny of its rulemakings and just more claims and litigation to raise against the agency.
So I have a question. When you mention these process manuals, do we know how many agencies have such things? I think the FTC has sort of a internal manual on rulemaking that I'm sure is available under FOIA, if nothing else. But Todd, did you try to find those as well?
Yeah, there's reference to internal manuals in the different case law that I analyzed. I didn't do a survey of them in the sense that I did that survey of rules on rulemakings, but a lot of agencies have them.
I imagine, as you hinted at, Peter, some are public and some are not, and there's a lot of variation, and it would be time consuming to get the full universe out there. All right, well, we could, if folks have additional thoughts on costs and benefits, that's welcome, but also curious about sort of the idea about how rules on rulemaking might be structured, and do we have a sense of whether or not the best practice to consolidate all rulemaking procedures into one rule, whether it's codified or not, or do it better to have a series of different rules. So I don't know if agency folks or members, public members have views about this sort of format and structure of rulemaking procedures.
Can we hear from
Kenny?
the FTC?
Kenny, yeah, I see you have a thought, Kenny.
Sorry, can everyone hear me? I forgot to double unmute. My apologies. I think Jeff referenced the FTC. So we do actually have, and I don't think it was in the report, which is of course absolutely fine. We do have sort of what are equivalent to rules on rules, but they're not really structured in the same way or the same nature as the DOT rules, I believe. For us as an agency, we have APA rulemaking authority under specific targeted statutes, and then for discretionary rulemaking under our Organic Act, we are subject to what have become known as Mag-Moss procedures, Magnuson-Moss procedures. So because those involve additional opportunities for requirements around an issuance of an advance notice of proposed rulemaking, for the opportunity for an informal hearing and sort of advanced procedural notions and hybrid rulemaking, we do have specific procedural rules that govern Section 18 rulemaking, Mag-Moss rulemaking. And in addition, for other statutes like the Fair Packaging and Labeling Act, which require some additional procedures which are slightly above sort of typical APA notice and comment, but are not sort of as stringent as Section 18 rulemaking. We have additional procedures of those in our rules of practice. So we do have sort of that. I'd say we do try to direct people to our rules. There's some internal guidance for the agency staff about rulemaking, and there of course would be, I guess, probably available under FOIA. But really we've tried to codify our rulemaking procedures sort of that go above and beyond basic APA procedures in rules of procedure. And so we have sort of very basic rules for other APA rulemaking.
Thank you, Kenny. That's helpful. If anyone has a follow-up on or question for Kenny, that's great. And if not, Danny has a follow-up comment.
Thanks, Connor. This is really interesting. Thanks for studying this topic. I just wanted to follow up on something that Ryland had mentioned. I agree that putting a rule in the CFR with an administrative disclaimer, no private rights or benefits, whatnot, still creates some form of litigation risk. And one potentially useful thing for the committee to consider would be to support the notion of making those administrative disclaimers, of encouraging courts to honor those administrative disclaimers, because there are potentially useful transparency benefits associated with putting something in the CFR, even if the agency does not want to make it judicially enforceable. And then I just had one other thought, which I think is hinted at on page 9, with respect to costs and benefits, that having regular procedures in the CFR or in an explainer that are also waivable at a high enough organizational level, where there's some accountability associated with the waiver, is one potentially useful way to deal with the inflexibility of having a rule in place governing procedures, forward-looking. So, thank you.
Thank you. Responses on that? Other points on costs and benefits of consolidating rulemaking procedures into one rule? Okay, well, let's take. Oh, sorry, go ahead. Go ahead.
I didn't fully understand the question, and is it the idea that you might have, if you had sort of, rather than general rulemaking authority, you had, as I understand the FTC does, specific statutory instructions to do rulemaking on a certain thing a certain way and rulemaking on a certain thing another way? Is the idea to have rules for sort of what we'll do in general, what we'll do in the specifics, or is the idea, here's what we're going to do in our notices, here's what we're going to do during the comment period, here's what is, so which is it when we talk about multiple rules?
Todd, I'll let you flesh out your thinking. I'll let you explain what you had in mind.
Yeah, so for that question, in the course of the research, we found some agencies like DOT that had this single rule that they published. It was just a package that included many different elements. So everything from retrospective review to public comment was all in a single rule. Other agencies like the EPA don't have something like that. So the EPA has what could be called a series of rules on rulemaking. So they might have, and I don't recall, Ryland can speak to the EPA rulemaking process much better than I can, but there are some rules that specify their process for maybe petitions for rulemaking, and other rules that specify their process for analyzing economic analysis of rules. And so they're not bundled together in the way that DOT and HUDs and FEMAs are. And agencies just do it. There are, agencies that fall into the EPA camp and agencies that fall into the HUD, FEMA, DOT camp. But I think that's what the question envisions, is what are the considerations for agencies that do decide to codify their rulemaking practices? How should they decide whether to do it as a single rule or a series of rules?
This is Ryland. So since Todd referred to the EPA, as everything you said there was right, Todd. So I note that we have an internal manual called the Action Development Process, which governs rulemaking generally. And so that is not a rule in itself. It's a manual. And then, as Todd noted, there are rules that address specific topics, like a recently released rule about guidance in response to the president's EO. There's a proposed rule about cost-benefit analyses right now. And then there's also some, I would think, many kind of very discrete rules that address procedures relating to a particular type of rule under a particular type of statute that we administer. So in response to the question, should we consolidate all rulemaking procedures into a single rule? I would just note that I think one difficulty of that is particularly where we have a lot of different statutory authorities that may prescribe for somewhat different rulemaking procedures. It just feels very practically burdensome, to get all of those program offices to work together and come up with one package. I think, maybe for agencies that have like a single rulemaking authority, that might be a little bit easier to manage, but that's just one thought.
That's helpful, and that speaks to some of the heterogeneity between agencies that makes it a challenge to generalize. Our next recommendation to discuss, I think, is quite meaty, and that's also partly goes to Sid's question about what's on the menu of options. So let's take a 5-minute break, and then we can start talking about the various options that we might or might not suggest to agencies to think about for their rulemaking. So tell me if I'm wrong, Todd, but should folks just stay connected, turn your camera off, and then come back at, say, 3:18? Is that right? Okay, so we'll see you all about 3:18. We'll reconvene then on number 3 about the various potential provisions of rules on rulemaking.
Hey, Connor and Todd, I came in a little bit late. Could I ask a question? I'm just not sure if we covered it while everyone's on break.
Sure. Yeah. Connor, should we just maybe pause the break for a second so Steph can ask a question?
Oh, you may have covered it already, so I don't think everyone needs to stick around for it. Feel free to take your break. But okay. I guess I was wondering, are we setting up a dichotomy between guidance on the one hand and legislative rules on the other hand? And have we considered the sort of possibility in between of a procedural rule that is published in the Federal Register with or without notice and comment? Because if you look at like the analog of adjudication, agencies publish procedural rules all of the time, and they invoke the Administrative Procedure Act exception for procedural rules to say, the APA's notice and comment rulemaking requirements don't apply. This is a rule of agency procedure, and then often they'll nonetheless solicit public comment. And so I want to make sure that we aren't saying it has to be a legislative rule or it has to be guidance when there is this middle ground option that doesn't impose on agencies procedures that the APA does not itself impose on them.
Can I just take that? I think, Steph, that's an excellent point, and I think some of it is worth your making when people resume, when the meeting resumes. One of the I think that at least as we're conceptualizing the project, or at least as Todd is conceptualized in the memo, we consider a procedural rule for purposes, or Todd, for the purposes of his memo, considers a procedural rule that is in fact binding to be a legislative rule, and that legislative is not being reserved for rules that have to go through notice and comment. With respect to the notice and comment issue, there was some discussion about yes, exactly your point, which is that there's an exception in 553 for procedural rules. I think there were, and Todd or Connor can correct me, or Reeve, I think there were some concerns raised by committee members, especially agency folks, about the sometimes difficulty of distinguishing between procedural rules subject to the procedural exemption and substantive rules that aren't. I think Alice Kottmeyer had a comment about that particular subject that we might return to. I think your larger point here, though, that agencies do have, we don't want to judicialize, to use Justice Scalia's phrase, the rulemaking process, but there is an obvious analog here and that is adjudication procedural rules, which agencies almost always have. Sometimes, as you point out, they voluntarily put them out for public comment, even as they're standing on the exemption under the APA. We can think of any number of recent examples where agencies have undertaken major revisions of their adjudication rules and still put them out for public comment. So I think it's probably it may be a point worth making, Todd or Connor, that there are a lot of rules on rules, and they govern rules on adjudication, and they govern an important part of the administrative process. Now, there are due process issues, and there are other reasons why you really do want binding rules, procedural rules in the adjudication context. But I think it's worth mentioning that they're out there. And in response to the comment that was made about, well, there are different rulemaking systems legislatively that may require multiple rules. Agencies have that's especially true in the adjudication context, where agencies have had to within a single procedural rule address multiple statutory schemes or in a subpart or whatever. So anyway, I think some of what you say has been discussed, and some of it is probably worth mentioning during the meeting whenever Connor thinks it's appropriate.
Hey, Matt, this is Jeff. You hear me?
Yeah.
Just real quick, I need to run off for a second. I'll be back in a minute, but I'm happy to circle back to that stuff. And you can make your comment, because I just think we did talk about some of it, but it's sort of fundamental. So I'm happy to return to that before we dive into the specifics. I'll be back in a few.
Matt, I was just going to say, in terms of adjudication rules, I think agencies feel like they need to do it sort of like the Federal Rules of Civil Procedure, because, you know, so many of those rules apply to what parties must do in the adjudication.
I agree.
Whereas in the rulemaking process, there's not so much you have to say about that. It's mostly about internal stuff.
I agree. No, I don't want to overstate the similarities, and there are certainly differences in the adjudication context. You've pointed out probably the key one. You know, adjudication is also infused with a lot of due process considerations that rulemaking isn't.
Right.
If there's going to be a break,
I wasn't meaning to suggest that because there are adjudication rules, therefore there must be rules on rulemaking, at least not to the same extent. I don't want to suggest that.
Matt, Todd, if there's going to be a break, I suggest really hasn't begun yet.
Who is this? I'm sorry.
That's Peter.
Oh, Peter. Well, we were just, I think we were just responding to Stephanie's, who joined late.
Of course, but there's a continuous conversation.
Yeah.
Okay, I'll take a break. See you all soon.
This conference will now be recorded.
Sorry, it would seem during the first part of the break, we had an interesting discussion. Just taking a little bit of a step back on kind of a foundational issue about the structure of agency rules. So, Steph Tatham, go ahead and give a summary of your comment, and I'm happy to reopen that because I think that sort of sets the stage for everything else.
Sure, and apologies to join late today. Thanks all for having me. I'm a member of the Committee on Judicial Review. Member from OMB, delighted to be here with you in the Committee on Rulemaking. So my question was really, you know, I was wondering if we could look at the analog of agency adjudication rules, which are often published in the Federal Register, and they say that they're procedural rules. They say they invoke, you know, the exemption for notice and comment under the APA for procedural rules, and in many cases, agencies take public comment nonetheless, which is something that I hope we would consider encouraging. But I guess I was wondering whether we need to take up the question of you know, whether or not this is a substantive rule or if it is a legislative rule, or if we could leave that to the agency and let them determine if it is a procedural rule, you know, whether or not they would like to go through notice and comment procedures. And I don't think that considering it a procedural rule is a barrier to putting regulations in the Code of Federal Regulations. Agencies often do that. So, you know, they say that this is a procedural rule. It's not subject to notice and comment, and it is in the Code of Federal Regulations.
Connor, I was part of this sidebar, if you will, or maybe it was a unauthorized break discussion, but I think Stephanie makes an excellent point. The analog of agency adjudication rules. I do think it would be helpful just going forward for maybe, if possible, for the committee to stipulate to certain terminology. And, you know, we consider, Todd uses the word legislative rules to cover a binding rule, whether it's procedural or substantive. Stephanie just used legislative rule in a different way. You think it would be useful just to stipulate on some common terminology here as we proceed through the discussion?
Yeah, thank you, Matt. I do appreciate that. I guess the point that I'm really trying to make is that there are analogs in the adjudication space, and there is an opportunity for an agency to take comment on procedural rules, regardless of whether or not they're required to under the APA.
And they regularly do so. I mean, there are any number of recent examples of agencies having revamped their procedural rules. The SEC, Connor, is one of them a few years ago, and those rules were put out for notice and comment, and the agencies in some cases got a lot of comments.
Yeah, I spent plenty of time on that project, so that continues to attract attention, as you know, Matt. So no, I think that's a great point. What do other folks? It seems like there's a lot of interest in this. So what do other folks think about this kind of foundational question about the status of these potential rules and what we might want to say to agencies? As well as the adjudication analog. To your other point, Matt, I think common terminology is something we should work on before the next meeting. I think that's hard. I remember an interpreted rules project, so much discussion about what binding means. And so I think that's something to work on, but we may struggle to reach common agreement today.
I do want to say just one thing that is settled in recent ACUS recommendations, and this is largely a result of Ron Levin's contributions, is we have used in recent recommendations legislative rules to refer both to procedural rules and substantive rules. That is, we've used legislative rules without regard to whether a rule is subject to a 553 exemption.
That's helpful. Thank you.
Yeah, and I think that makes sense, and I'm okay with the terminology as scoped. I'm happy to refer to it as a legislative rule if it's intended to be binding either within the. What I meant to say is, in terms of the procedures that you go through, going through a rulemaking to adopt a procedural rule doesn't necessarily mean that you're obligated to stick to notice and comment to change that in the future, even if you've taken notice and comment in the first instance.
Danny, I think you have a comment on this point. Danny Fischler.
Yeah, thanks. We have a very small rule on rules at DHS headquarters on petitions for rulemaking, and we did that a few years ago. I love that rule because it creates some transparency and settles some confusion about what qualifies and what doesn't and how we respond. We issued that one as an IFR because we didn't want to wait for the notice and comment process. It wasn't a high priority rule from our leadership's perspective, but it was something that we thought was important for how we do business. And so we wanted to just get something on the books, and we used the procedural rule exception to do that. And then we just closed it out a few months later. And that was actually really useful to be able to take advantage of that flexibility. So to the extent that flexibility exists in the law and the committee decides that these are the kinds of things that agencies should be encouraged to do, I think emphasizing that the flexibility exists could be useful. I'm not sure that everything that's described here necessarily counts as a procedural rule, and maybe it would really depend on the particular application, because there's all kinds of strange exceptions to the procedural rule concept. But I think where the agency can make the argument and that makes a difference to the agency, that's helpful.
Further discussion?
This is Jeff again. I certainly agree that these types of rules would be good for the interim final rulemaking process. You could get public comments, but you wouldn't necessarily have to wait, assuming it is a procedural rule or a guidance document. But I'm still troubled by the fact that we say in the report that legislative rules are binding on agencies and the public. Agencies therefore must adhere to their legislative rules. Notwithstanding what Dan Cohen said, the agencies would typically want to adhere to the rules that they've come up with. I don't want to discourage agencies from doing it for fear that they're going to get sued.
Hi, this is Jonathan. Could I follow up quickly on Jeff's question?
Please.
Yeah, sorry, I don't mean to jump the queue. I also have to go teach now in a minute.
Thank you for joining us.
Yeah, oh, my pleasure. This is quite interesting, and I appreciate the report, the memorandum as well. And I'm wondering to what extent we all think, or the memorandum should say more about whether binding, to what extent bindingness is truly binding, in the sense that if an agency issues a general rule on rulemaking, and then later in a specific rulemaking, can it exempt itself, or can it give reasons for departing from the general rule on rulemaking, which might be because of something in its statute, but it might be for other reasons. And perhaps those reasons themselves would be subject to judicial review. And so there would be a probabilistic increase in the agency's adherence to its rule on rulemaking, but not 100%. And maybe that's desirable, that there would be some latitude there. So just curious, it seemed to me the memorandum could say more about that question of what we mean by binding.
I'd be curious if DOT has encountered this in respect to specific rules, and maybe there's an exemption in the rules and rulemaking that you apply, or if this point has come up for DOT.
Sure. We do have exceptions built into the rule, but we haven't encountered it in a particular rulemaking. And Jill, is there anything to add on that?
I think so. I know, like, with regard to our special procedures for high impact and economically significant rules, we have a waiver procedure built in. And if you read throughout, there'll be exceptions here and there, except otherwise provided by the RRO and things like that. But I can't think of any come up recently with regard to a specific rulemaking matter.
That's something Todd or others have encountered, you practice your case law?
I think what I've seen is just what Jill has pointed out, that there is a lot of language in rules on rulemaking that, for example, there's waiver authority built in, or there's some language except to the extent decided otherwise by someone within the agency. I haven't seen examples of invocations of those exceptions in particular rulemaking.
It's an interesting point, Jonathan. I would think the exceptions usually apply to it, but rules can be changed by other rules. So something interesting to think about.
I'm not sure if this is getting to the question, but in case it is, I mean, there are cases that say agencies can deviate from their procedural rules in their discretion, so long as it does not prejudice a litigant. And one might argue that's similar to the APA's rule about prejudicial error, but there's a specific case law, including at the Supreme Court level, that says that.
Other comments sort of on this sort of general question about how rules should be structured under the APA. If not, we can move into the specific menu of options, which I know Todd is eagerly wanting to dive into. Okay, well, we can always revisit, but so recommendation 3, I won't read the whole thing to you, but you have the this menu of options, and as Todd says here, we likely don't want to dictate provisions on rules, but we may want to consider providing a menu of options. And so Todd has a list. So I welcome thoughts on anything in this list or other thoughts as well.
Hey, Connor, this is Bridget. Could you just clarify what page of which document you're looking at?
Very sorry, Bridget. We've been marching through in Todd's memo. At the end of page, my document, it's page 10. So it's the third question in the issues for the committee to consider. So it's section 5 of Todd's memo, the very end, page 10, question 3.
Okay, but you want to take the occasion to converse with her about.
Got it. Thanks. And Peter, we can hear you. You're not muted.
Okay, good. Thank you. Bye-bye.
So anyway, we can march through thoughts on any of these items or additional items. I will turn my mic off and let folks jump in.
This is Steph. I have an additional item or a friendly amendment to C. Love to see the inclusion of ex-ante regulatory analyses, but often rulemakings amend existing rulemakings, and so I think we should consider, where appropriate, ex post regulatory analyses as well.
This, Steph, is this beyond retrospective review at the bottom, something beyond that?
Oh, thank you. No, it is not beyond retrospective review, so I will retract my comment. Thanks, Connor.
Other thoughts on this list? Pros, cons?
Hi, this is Jill from DOT. One thing that I don't see on the menu of options that might be worth considering, and I don't know if other agencies have these, would be procedures for formal rulemakings or formal hearings. I don't know, maybe if like FTC or CMAs that do these more frequently might have these in their rules. I know DOT, we mentioned what types of rules would be would fall under, would require formal hearings, so we don't actually spell out the specific procedures in our rule on rules. Yeah, so Jill, I know that the scope of the project excludes rules related to formal rulemaking procedures, so that's why it wasn't included there. But there's something, I guess, was your suggestion that there should be one of the menu of options should be rules related to how agencies conduct formal rulemaking under 5 USC 556 and 557, if I have my sections correct? Yeah, sure. That, or if an agency's rules require them to do formal hearings for certain types of rulemakings, if that would be in their rules on rules. And I'm sorry, I might have missed that the scope was limited to informal, but just wanted to throw that out there for the menu of options.
Yeah, the ACUS Council approved sort of the scope is informal rulemaking, and there's a 1-paragraph description on the project webpage.
Does that exclude hybrid rulemaking?
Well, Jeff, I could probably say with complete certainty that nobody even thought about that. I think that if the committee thinks that there's something about formal rulemaking or hybrid rulemaking that really needs to be in this recommendation, I'm sure the council would, I don't know, probably look favorably upon it or not be concerned with the scope of the project as it's set forth in the project description. But I think it really depends on what we're talking about here. Reeve, is that fair enough?
Yes, I agree. Correct.
I mean, I didn't mean to throw any kind of a crowbar into this. It's just that that's consistent with the previous comment that some agencies have to have hearings, or some agencies have to have advance notices of proposed rulemaking, which is something that's not on the list, for example. And one other thing that I don't see on the list that might be of interest is that in multi-member boards and commissions, there are sometimes dissents. And how do agencies handle dissents? Do they publish them somewhere? Or I mean, that's a possibility, at least.
If we don't have follow-ups on this, and I welcome those, then we'll go Erica, Bridget, Danny. I would recognize the queue, but before we go to Erica, any follow-ups on formal rulemaking, hybrid rulemaking, multi-member agencies?
Yeah, could I just add, as part of my research, the list that we came up with was from a review of the 25 rules on rulemakings, and the most salient issues that we found in those rules on rulemakings. It's not to say, all of the issues that people have pointed out are addressed in one or another rule on rulemaking, and you can always expand the list. The list can be much longer than this, but hybrid rulemakings were not, I did not see in the research that I did much by way of procedures related to hybrid rulemakings in rules on rulemaking. So that's not to say that you can't suggest that as a menu of options, but just to give the committee an understanding of where this list came from. It was from an extensive review of all existing rules on rulemaking.
I know Kenny had to drop off, but it's something he probably knows, given the FTC's focus on that.
I don't even, Jeff, is it if an agency has in the case of formal, if an agency it has to undertake formal rulemaking, or is chosen to, I suppose, doesn't it already in every case or most cases already have a rule on rules governing formal rulemaking? Is this something that needs to be on this sort of illustrative list of things that agencies might include in a rule on rulemaking?
You're asking me? I mean, I think if we're trying to come up with a list of a menu, I think we should be as inclusive as possible. And I've added a few more, like direct final rulemaking. I know some agencies have rules on that. We just talked about interim final rulemaking. And so I think if agencies have hearing requirements or requirements for ANPRMs, that should be in their rules.
I guess what I'm asking is, are they already, if they have a formal rulemaking apparatus set up, don't they already have a rule governing those proceedings? That's what I'm getting at. Maybe
well, the FTC, apparently the FTC staff manual does, but I don't know about anything in the CFR.
Anybody else have knowledge or comments on this point, or about direct final or interim final rules? Adding those in. Steph, I see you second Jeff's point, but I'm not sure which item or which items.
His recommendation to be inclusive and consider the format of rulemaking, which might include whether to have a hearing, whether to go direct final, whether to have an ANPRM or interim final rulemaking. I'm not sure that's the right chapeau for those concepts, but taking an inclusive approach, considering issues like those.
Erica?
Yes, I guess I wasn't clear from Todd's final comment whether we are actually being invited to add to the list A through J, but one thing that we might consider in addition to minimum comment periods is procedures and standards for extension of the comment period.
I will say in practice, that does come up quite a bit in practice, in my experience. Thoughts on those suggestions? Hearing none, Bridget?
Yes, and I'll turn my camera on, though it looks like I'm in witness protection given I'm backlit. Hi, everybody. I was thinking that you could probably broaden F, which says submission of sensitive information, and it gives the example of trade secrets. You could probably round that out more with basically comment handling and docketing in general. I think agencies have a fair number of policies around, like, you know, how they'll treat the comments, whether they'll post them, within what time period, that type of thing, and, you know, how to catch errors and confidential business, or not errors, but how to, you know, apply for confidential treatment, that kind of thing. This strikes me as something that could just be rolled into that, although, you know, it may well be codified elsewhere. But I think a fair bit of this just exists in policy document, and if you were going to take the trouble to make a procedural rule, you might fold that in here. Also, I think policy around, you know, the treatment of anonymous comments or pseudonymous, pardon me, comments. This would be a fine place to state agency policy on whether they accept anonymous comments, et cetera, et cetera. So it's just two ideas to broaden this list a little bit.
Does AGUS have a pending project on anonymous comments, or am I getting that confused?
So we do have a project looking at mass computer generated and fraudulent comments.
Okay.
One of the threshold questions within that is, you know, do agencies take anonymous and pseudonymous comments, and how does this differ from fraudulent comments? So that will be part of that. We also have recommendation 2011-2 that generally just says agencies should have policies on such things. It doesn't go into, you know, what the content should be, but it indicates that agencies should have a policy on that.
That recommendation, though, does specifically, you say such things, but those such things include anonymous comments, correct? Aren't anonymous comments specifically mentioned?
Correct.
Yeah, okay.
Yeah, and I think as a general point, I mean, in any prior ACUS recommendation that encourages agencies to have a policy in a rulemaking area, I think should be considered for this menu of options, right? I mean, this seems like a natural fit. If you're going to write a procedural rule, and ACUS has previously opined that you should, you know, consider committing pen to paper on your policy around any of these areas, that this would be a fine place to codify that.
Follow-ups on what we discussed so far. Let's see, I think, Danny, did you have another thought?
Yeah, I think it's along the same. Good. It's along the same lines as what Erica was describing. I think this item G, minimum comment periods, maybe to broaden it to conduct of the comment period, and then add some examples. Some of the other examples that I was thinking of related to, for instance, what Sid Shapiro was describing earlier with respect to outreach to affected communities, as well as the decision whether to issue an ANPRM. And what Professor Shapiro had mentioned made me think of the section 203, 204 of UMRA requirements related to consultation with small governments, and their consultation requirements with respect to impacted tribal governments as well. That all those things might be amenable to a rule on rules as well.
Andrew, Emery, I see you had a comment. Did you want to add to the discussion, or did folks cover what you had in mind?
I think it's been covered. I just wanted to mention that, I mean, there are a lot of these topics that you're bringing up that are currently covered in a lot of agency procedural rules. My only comment I'd like to make is just that just a fear of, in these kinds of situations, of over-regulation, that agencies sometimes with procedural rules sort of over-regulate themselves and wrap themselves around the axles, where they'll suddenly have something that's preventing them from acting, that often even internally the agency staff will say, oh, we're not allowed to do this because of the APA or an executive order or something else. And the truth is like, no, really nothing prevents you from doing what you want to do other than your own procedural regulations. And so I think it's often a sort of a caution that there's lots and lots of process out there and agencies often risk overly proceduralizing themselves with their own procedural regs. And so I think that's one word of caution, but then also the caution just to sort of to our group of not adding to it. Sort of, I think I've been on a lot of rulemaking teams within different agencies where once they get into regulating something, everyone thinks of every possible thing you can do to regulate it more. And it's sort of like, you know, how much really needs to be down and binding everyone. So that's just sort of a word of caution.
Yeah, and that's something Todd had sort of spelled out in question 1, which I thought folks would want to talk a lot about. I do think that's something we will consider drafting a recommendation as that trade-off. Further thoughts on Andrew's comments?
Mike Livermore, if I may.
Please. And Jeff Fulvers, I see you will go to reply comments in a minute, but go ahead, Mike, sorry.
Yes, so I just, kind of agree with that general concern about over proceduralization, and maybe something that we can kind of think about as we're moving towards the recommendations is ways that the recommendation can actually avoid this problem or highlight the concern about too much procedure, making it difficult for agencies to act. And so that seems like something that we can kind of address head on, and doesn't necessarily mean that I don't think it invalidates the project, but it's something we can kind of substantively address.
Did you have specific thoughts, Mike, or is it something, if you have other thoughts?
I'll have to mull that over.
Yeah, we welcome, I should have said this before, any feedback in drafting you want to send to Todd and me and Reeve is extremely welcome. Other thoughts on this proceduralization point?
Yeah, I think I do. And I think it relates to, part of what I was going to add to, this is Bridget, was going to add to Danny's point. There's a whole slew of executive orders, right, that put consultation and other analytical requirements on agencies. I'm thinking of the federalism EO, and there's plenty of others that we're all familiar with, probably several dozen in all. You could imagine adding those to this list. I mean, I see this particular exercise we're engaged in as the development of a menu, right? And so it's not a list of things you have to put in, but if you're going to do it, there are sort of pros and cons of codifying procedures, of course. I guess at this stage, I would counsel for putting all the items on the table that we can think of, again, in the spirit of a menu. And then if we ultimately decide to pare that back and really only recommend a few, so be it. But I wouldn't want to cut short the conversation of, what other types of considerations agencies might have that they might want to fold into a procedural rule. It feels a little too early to cut short that conversation.
Further comments? Jeff, reply comments are something we've talked a lot about, the ABA. Did you want to speak to that or just throw that on the potential list?
Just to throw it on the list, it's something that ACUS has previously recommended that agencies consider. So it's kind of consistent with the point that was made earlier that we should go back and look through the ACUS recommendations.
Mm-hmm. Outreach and consultation stuff is something that I think maybe a more general way of framing what Professor Shapiro had said earlier. Anjali?
Hi. I have a comment for a suggestion on the list, and it tags off of a suggestion that a lot of other people have made, and thanks for including me in this discussion. Several folks have mentioned the possibility of the rules being too restrictive once the agency adopts and codifies them, and some have brought up the option of a waiver or other release valve. What if we just put that as one of the options in the menu?
Do folks think that's worth spelling out or implied? I don't have a strong reaction, but
I think the express blessing of waivability is something that, just from the perspective of someone who works at an agency, is very useful. I think we get a lot more traction issuing some of these rules, the more flexibility we can build into them.
See, plus one vote for that was from Bridget. My sense of the committee is that folks want to be expansive in the list, at least at this stage, in the menu of options. But if there are folks who disagree with that sense, let me know. Well, why don't we move on then, taking the sense of the committee and going back to look at all the prior ACUS, comb the prior ACUS recommendations, which read those them by heart. We will take the sense of the committee in that. And let's go on to number 4. And Todd, I should have mentioned this before, but would you mind just speaking a little bit about some of the prior ACUS recommendations on public availability? You've laid out some of them, but just maybe a general sense of what ACUS has recommended in the past, because I know there's been a lot of work done, including by this committee in 2019. So if you want to just give a quick summary, I'm sorry to put you on the spot, and then we could talk about ideas for this recommendation.
Yeah, so ACUS has, I think, a trio of recent recommendations on public availability of materials. We have public availability of guidance, public availability of adjudication rules, and then adjudication materials on agency websites. And without going through the specific suggestions in each one, I'll just say overall, they encourage agencies to place these materials on their websites and to not just throw it up there and let people find it, but to logically organize them, to index them, create databases where people can search for things, and have agencies organize these materials logically so people can see where they fit into the agency's overall body of procedures. So that's what those recommendations say overall. And we wanted the committee to be aware of these, since a big part of this project is transparency. Just whether an agency issues a rule on rule or other kinds of documents related to their rulemaking process, I think it's ultimately up to the committee, but I think it's safe to say that there will very likely be some transparency piece of any recommendation that comes out. So in thinking about ways in which agencies can be transparent with respect to these materials, we wanted to bring these 3 recommendations to the committee's consideration, so that anything we recommend is consistent with them.
Of course, some parts of these recommendations are geared toward things that agencies have a higher quantity of, such as guidance documents, whereas rules on rulemaking are presumably a more discrete thing. But I think there's helpful ideas to bring it through. And my sense would be to try and pull those in and draft a recommendation consistent with these recommendations. In particular, the guidance document one seems highly relevant. But I welcome reactions from the committee. Possibly the adjudication rules as well, Matt, to your point. Comments on number 4. Again, this is pages 10 to 11 of Todd's memo. If not, we'll work up something for folks to consider.
I would just say that maybe down the road, these 3 recommendations plus this one could be consolidated into one recommendation on public availability of important regulatory documents. That's just something to think about in the future, since we would have 4 of these by then.
There actually are probably, depending on how you count, there are probably 6 or 7 of them now. So
yeah.
Anything further? So number 5 is, oh, sorry, did I hear something? Something that may be feedback. So number 5 is something we talked about some in the general discussion. The agency issues explainers, and I think people had different reactions. About whether or not it's a good idea, but do we have thoughts about how to make those accessible and clearly marked as non-binding? So I welcome additional thoughts from our prior discussion on question 5.
Connor?
Yes.
Could I go back for a moment to number 3? I'm sorry, I had to be out of the room for a bit.
Sure.
And that is, I think that there ought to be some part of the list ought to have to do with the content of notices of proposed rulemaking, and specifically the obligation to share data.
And so would this sort of be a synthesis of some of the Portland cement line of case law, or did you have something different in mind?
Well, the Portland cement line of case law, but at least as I regard it, also the obligations of the Freedom of Information Act.
Mm-hmm. Reactions on that idea?
Maybe it's a good question. Peter, was that in the line of like something that would go on the laundry list?
Yes, exactly.
Okay, hearing no reactions, we could include it or draft it up and see how it looks for committee consideration. So returning then to number 5, reactions about explainers and how to make those accessible and distinguish them from binding rules.
Well, I have a comment on this. That's okay, Connor.
Please do.
So I'm all in favor. I like explainers for the reasons that Peter said earlier. But I think it's a little confusing. There are explainers that are not legislative rules, and then there are also non-legislative rules on rules. So I think this is kind of a third category that we're saying something about. And I guess we would need to be concerned about the comment that was made earlier that agencies don't issue too many different versions of the same thing, and they issue something that's in plain English that somehow elides the complications in their other rules on rulemaking. So I think, we might urge agencies to, in their websites, to try to do some of this. But I think we need to be careful about how we explain it, how we explain the explainers.
Connor?
Yes, go ahead. I see Peter. Yeah.
Yeah. Is there any way in which I can share my screen?
I defer to Todd or the tech expert.
You should be able to. If you see 3 icons at the bottom, mic, camera, and screen.
Right, there's a thing that says to share your screen, ask the organizer to make you the presenter.
I see. I can make you the presenter then, if
Someone
there are
just
any objections.
This will be fast and humorous.
All right, give me 1 second.
Someone already did it, I think, Todd.
Oh, someone did it. All right, so you should be able to.
Thank you.
Okay, so this is something that the general counsel of the FDA at the time, Dan Troy, gave me years ago as an explainer of half of the process at the FDA. There's an equivalent one for the initial rulemaking process. I'm happy to have you take things back now that people have seen this. I don't need to be up anymore. I think that this recommendation 5 about explainers both ought to emphasize them, as I said previously, and I think Jeff agrees, but maybe most importantly, to have an element of them that things explaining the agency's rulemaking process should be on the front page of their web, or should be at the very least on the front page of anything of their rulemaking segment, if they have such a segment.
Steph, did you want to speak to the revisions to the reg map on this slide?
No, I'm sorry. I was just providing side chatter because Peter's graphic, which I thought was very informative, reminded me that there is a government-wide reg map that we publish on reginfo.gov. And this was prepared by GSA, not by OMB and by contractors at GSA. But I was just noting in chatter that it was originally created in part by David Pritzker and recently got a refresh if anybody's interested. So to the extent that we're looking at those sort of agency process maps as potential data points, the reg map is intended to be a government-wide one.
The striking thing about that reg map is that there is no mention of the White House engagement through Executive Order 12866 or anything else like it.
Ryland, did you have a comment?
I did, thanks. So number 5 makes a distinction between non-binding background materials and binding rules on rulemakings. And I guess I wonder if that's the most useful distinction to draw. As I see it, from the conversation we've had, I feel like there may actually be 3 different distinctions. The first bucket being rules that are judicially enforceable against the agency. And the second bucket being rules that are, as a practical matter, binding on agency staff. And the third bucket being descriptions of the rulemaking process that are non-binding. And I would note that, for that second bucket, right, of things that are practically binding on agency staff, it's still binding in a sense, but it doesn't have to be a rulemaking, right? Like tomorrow, the general counsel can write a memo to staff that says this is how you must do things relating to settlements, and I'm going to follow that memo. And I also note that, as we talked about earlier, you can have rulemakings that are in the CFR that are not judicially enforceable, just like this DOT rulemaking in the appendix purports not to be. So I wonder if that's a more useful distinction for us to kind of think about for purposes of question 5.
Ryland, you had mentioned earlier, referred to an EPA internal, I think it was, I can't remember the name of it, but some type of internal rulemaking manual. Would you consider that to be in bucket 2?
I think so, yeah, because that's not judicially enforceable, right? But it is something that staff follow, and there are processes in it for when a process step can be waived, but it's something that staff do follow.
Folks think there's value at agency-specific explainers. I mean, I know DOT has done some of this in the past. I'm not sure if it's still up, but do you think these sort of more general things like the reg map or Mark Seidenfeld's thing that are sufficient?
I would think that there's value to agency-specific explainers if the agency's practices are idiosyncratic, which they frequently are. So, I mean, it seems to me that is the time when you really would want the explainer.
Yeah, I agree. I think, the IRS, for example, has its own overview of the regulations process. And we've already heard about the FTC's somewhat idiosyncratic rulemakings.
Other comments, thoughts on number 5, the general set of issues? Todd, did you have anything more about the prior ACUS recommendations that we should think about that you've highlighted?
Yeah, so I highlighted for this section recommendations on guidance documents. So I believe it was 2017-5 and 2019-1 on policy statements and interpretive rules, respectively. And in those recommendations, well, in the policy statements recommendation, we suggest that agencies include a notation on policy statements themselves that say that these are not legally binding documents. Interpretive rules has a similar set of recommendations. It doesn't use that phrase exactly, but it makes clear to agencies that they should structure their interpretive rules in a way that conveys the idea that they are not binding. So if we're going to make a recommendation here on these background documents that are clearly not legislative rules, the thinking was that the committee should consider these recommendations.
Any further reactions to this sort of explainer subject, or what we might draft as a recommendation? Then moving on to the last, this is the bottom of page 11, the principles. I think principle 1 we've talked about a fair amount with respect to substantive and procedural provisions and notice and comment and the relationship, and I think that's a kind of a core foundational issue. And then number 2 about binding language. So I will just open the floor. If people have further thoughts on notice and comment with respect to substantive procedural provisions and what we might say on how to characterize rules on rulemaking, or on number 2, I'll open the floor for both. Well, we've gotten good feedback on number 1. Does anyone have any further thoughts about number 2? Seems relatively unobjectionable to me, but any other comments on number 1 or number 2?
I had a question about number 1, and I apologize if this is like super basic, but what is the alternative to what's suggested here? Is it that the agency issue 2 different rules, one substantive, one procedural, and not put the procedural one through notice and comment? Or is the alternative that there's only one package, but the agency explicitly solicits comment only on the substantive portion, and then says, comments on the procedural portion are not going to be read, or something like that? Just curious what the thought process there was.
Todd, I'll let you explain what may have come up in your research.
Yeah, I mean, ultimately these principles are for you to react to. So I think any of those options or other options are fair game for discussion. I think the idea here was that what I found in these rules on rulemakings is that, and again, the line between substantive and procedural is often blurry, but the extent that it can be drawn, a lot of rules have what can be fairly described as both contained within them. So they'll have clearly procedural provisions, things like how you should label or whether you should put your name on a particular submission to the agency or something like that, which courts have found to be procedural. And then areas like the value of what VSL should an agency use, and other elements that would be considered clearly substantive, and they're often combined in a single document. So here we were just making clear that if that's the case, I think it's pretty unobjectionable to say that the agency should not consider that entire rule to be a procedural rule. That is, even if 99% of it is procedural and 1% is substantive, it would be improper to invoke the procedural exception for the entire thing. As far as what the agency does, whether it splits it off into 2 separate rules and engages in notice and comment for the substantive part, or whether it just chooses to put the entire rule through notice and comment, notwithstanding the fact that most of it's procedural, I think that's very much a subject for discussion. But that was the thinking behind the question.
Okay, thanks. That's helpful. I guess the impression I got from reading the text was, if we want to do one rule that has parts that are substantive and procedural, then the recommendation is that we also should put those procedural parts through notice and comment, even if they are clearly procedural. And I guess I'm not sure what's that there's a really good basis for that. Or I'm curious, what is the basis for that? I'll throw out another like scenario for you to react to, which is, let's say, we do a notice of proposed rulemaking that has both substantive and procedural parts, so we're following this principle. And then at the final rule stage, the policymaker decides, oh, I want to add, several additional procedural provisions, which under the APA don't have to go through notice and comment. Is the recommendation saying that that kind of thing should not be done? And if so, why?
So Ryland, would you feel better if it just said agencies should consider putting the entire rule through the notice and comment process?
I think that's probably done anyways, right? If there's a significant rule, that's always something that's considered.
But it would be making the point that even though some of it might not need to go through notice and comment, it might be a good idea so people could see the entire whole and put it all through notice and comment. But should ensure might be too strong. I don't like the word always in the heading either. But we're not trying to be overly prescriptive with this recommendation.
Could this requirement, well, okay, not requirement, this encouragement, however it ends up being phrased, have the unintended consequence of prompting agencies to bifurcate and not sort of present their thinking in a coherent single document? I don't know if it would, but it's worth thinking about.
And my sense from the prior discussion is some folks thought yes, or maybe some folks thought it would be a virtue.
Right. I guess what I'm inclined to think that there's a real downside to urging that something which is not required to go through notice and comment be put through notice and comment simply because it happens to be in the same document with something that does go through notice and comment. I'm concerned partly for, I guess, Lyland's reasons, and partly just because I think it could create some strange incentives for the drafting.
I think that's all helpful. I want to ask Todd or Matt or Reva, are there other issues that would be helpful to discuss that you want to follow up on in trying to come up with a recommendation? Stepping back and looking at the whole discussion of today.
Todd, you want to take that? I mean, I guess from my perspective, I think that this has been an excellent discussion, and I think it gives us a lot to go on in terms of putting together a draft between now and the next committee meeting. I think we have sort of a good conceptual sense of sort of where the committee is on these different issues, and this gives us good guidance in terms of a draft recommendation we can prepare to consider in connection with the next meeting. But I don't know if Todd or Matt have anything further to add.
No, I don't. I think. Sorry.
Go ahead, Todd. No, go ahead, please, Todd.
I was just going to say, I think we hit the points in the memo, so I can't think of other areas that we need to discuss at least in order to put together an initial draft for the next meeting.
I agree with all that. I think the committee would be at this point best served, Connor, by seeing specific recommendation language to which it could react and propose modifications to.
To that end, if folks have suggestions, if you folks mentioned citations, if you have ideas, please send it our way. It's always helpful to have stuff in writing. Todd will send out a reminder for the next and the link for the next meeting, and we'll proceed as Matt just said. And thank you very much for your feedback, for doing a 2-hour and 17-minute online call and for participating so actively. I really appreciate it and look forward to our next discussion.
Thanks very much, Connor. Well done.
Thank you. Take care.